Hello and welcome. I'm Amritanshu Rai. You're watching Rajya Sabha TV and this is Constitutionally Yours. In this program, we make an attempt to demystify the constitutional provisions. In this episode, we'll be discussing the special status of Jammu and Kashmir, especially in reference to Article 370. Joining me in this endeavor are an eminent panel of guests, Justice B.L. Bhat. He is former judge, Jammu and Kashmir High Court, nominated by the Chief Justice of the Jammu and Kashmir High Court. I have with me Mr. Ishak Qadri, former Advocate General and a member of the National Conference, nominated by the leader of the largest party in opposition in the state. And we also have an eminent lawyer, Mr. Zaffar Shah, who has immense experience and is a leading light as far as law is concerned in Jammu and Kashmir. We also have students from Kashmir Law University. Now, the permanent resident, the definition of permanent residents in the state, there was a notification in 1927 and also April 1927 and also June 1932. This was much before the independence came to the state. And the permanent residents as described then was specially for women, and this has got in reference to women only. The wife or widow of the state subject shall acquire the status of her husband as state subject of the same class as her husband, so long as she resides in the state and does not leave the state for permanent residence outside the state, which actually disallowed any Kashmiri person marrying out of the state as permanent resident, and was basically taking away the right of the women who was getting married outside the state, and she could not inherit the property which a permanent resident normally inherits. But this anomaly was corrected later on in October 2002. The full bench of Jammu Kashmir High Court, with one judge dissenting, had held that the daughter of a permanent resident of the state will not lose her permanent resident status on marrying a person who is not a permanent resident, and will enjoy all rights, including property rights. However, the discrimination persists. The implementation is still very weak. By the way, this judgment is still operational because the legislature has not done anything to touch this majority judgment. My question is, sir, when this right has been given to women, why is there a problem in implementing this? If women are allowed to go and marry outside, and if they want to, why not allow them the status of permanent resident and the property that is rightfully theirs?
You are referring to notification of April 2, 1927 also.
Yes, sir.
Note 3.
Yes, sir. Yes, sir. Permanent resident.
The purport and scope of that note is entirely different.
Okay.
If one reads that between the lines, what comes out is that that note refers to the case of a woman who is not a state subject,
Okay.
and has married a permanent resident of the state,
Okay.
a state subject. Now then she will have the status of a wife or a widow if the permanent resident of the state dies, and then she doesn't reside in the state, she goes outside the state.
Right.
She will lose the right of what we call status of permanent resident.
Okay.
That note is referable only to, in my humble opinion,
Okay.
as I have been able to understand it judicially, that it refers only to a case of, because otherwise if you talk of a woman in Jammu and Kashmir, say who is the daughter of a permanent resident of a state, this note will not apply, because she would otherwise also be a state subject, her father being a state subject.
Correct,
there is no
correct.
difficulty in that. This note refers only to a non-state subject woman marrying a state subject.
But then the judgment further goes on and elaborates completely on something which was not happening, which means any permanent resident who has the status of a permanent resident, even if she marries out or even if the
She would be, in terms of the full bench judgment, she is entitled.
but where
Unless,
is
of
the
course,
problem of implementation?
Unless it has been stayed, I don't know. So far, my knowledge goes,
There
it
is
has
no
not
stay.
been stayed by the
The
Honorable Apex
legislature
Court.
has not acted
It
on
has not been
Sir,
stayed.
what is the problem of implementation?
No, that will be exactly which the present government will be able to state what is their problem. But as far as the controversy is, that stand is
This was also there when
correct.
your government was there.
Correct. There are government implementations where as at that time was what we should write to her. That I sorted out, but it was subject to the approval of the cabinet, which later on because of the elections could not take place, and it is now with the state government to say what to write about her. Suppose before this law came into by way of a judgment, we used to write about the woman till she marries.
Valid till marriage.
Valid till marriage. It was so because once she will marry an outsider, she will lose by virtue of the constitution and by virtue of the notification of the 27. Now this has gone. But once we write that she is a state subject, what about her children? Because this domicile law rests on the male. It doesn't rest on the birth from a female. Therefore, questions were put here to me also in so many files, what to write to their children if they come that we are the son of Mr. such and such who had married an outside. I continue to be my mother continued to be the. So, our view at that time was they are not state subjects. Therefore, what will happen to the property? Those were the questions before the government at that time. That is why it was not clear. But it must now be cleared, because what will happen to their property?
So it's been nearly 13 years since this judgment was made. There's been no clarity. Is there a lack of will? Zaffar Saab, is there? It's a progressive judgment.
Yes,
No one can deny the fact that this is a progressive judgment, and this is happening all across. I mean, you can't have an isolated Jammu Kashmir just going against the normal phenomena where progress is coming in all aspects of law.
Let's see whether it's a progressive or not. You need to appreciate first one thing, the concept of nationality. It is an accepted principle of international law and in many jurisdictions that the wife would acquire the nationality of her husband. Now this was the principle accepted, and this was the principle which is adopted by the ruler at that time in the notification of 1927, that the wife would accept the nationality of her husband. This is fundamentally. Now what has happened is that this position continued in the state of Jammu and Kashmir. You have two kinds of examples. One would be when a girl from the state of Jammu and Kashmir would marry a person who is non-permanent resident. Based on this principle, the law held that she loses her status as a permanent resident. This is one aspect.
That was the notification.
That still holds true. It is not revoked. Notification is applicable when you and I am talking.
Okay.
This notification is constitutionally protected.
Correct.
We have few provisions like Article 35A, they protect all these notifications. So therefore, we should not have any doubt on the applicability of the notification. I will give the reason also about the
Correct. I've got your point.
I'll get you on the judgment of that. That's
on the judgment,
important.
yes. On the judgment.
Now, second situation was, because the judgments are delivered in a context. If you drop the context, the sentence becomes misleading. So we have a context of the judgment. Second was that if a girl from outside state of Jammu and Kashmir would marry somebody who is a resident of the state of Jammu and Kashmir, she would on the first principle acquire the nationality of her husband, would become permanent resident. Now what did this judgment do? This judgment for the first time reversed the whole legal position which was applicable in the state from 1950 till 2005. This judgment, entire judgment turns on a single word. It's a judgment based on dictionary. There is a word used in the notification which says that the woman would acquire nationality of the husband. What does this word acquire mean? The two learned judges who were from Punjab interpreted this word acquire saying that acquire means something which you don't have.
So they being from Punjab is not relevant.
I'm
I think
trying to
judges
tell
are
you.
judges, sir.
Of course, I'm
They
just
being
telling
from
you.
Punjab should not be a
I'm telling you why I said so. I said so for a
Dissent
reason.
was from
The
local.
dissenting judgment is from here. The dissenting judge, the learned judge is from here, because as I told you, whenever you deliver a decision, decisions are never like mathematical propositions. It is never black and white. It's a gray area. Decisions, all decisions are tempered with the personal experiences of the judges, the social influences of the judges. It's absolutely not correct in law to say that the judges deliver decision 100% according to the book. This I'm trying to tell you.
Likewise for the dissenting judge.
Quite right, quite right, quite right. The dissenting judge felt, dissenting judges pointed out the implications of such a proposition, holding, as my friend said it, that if you say that a girl who marries an outside continues to be the state subject, continues to be not a state subject but a permanent resident, then obviously in the matter of inheritance of the children, there would be a problem. What do we treat children as? Now, in matters of inheritance, it is the personal law of the parties which is applicable. So, under Islamic law or under Hindu law, the children would inherit. What will be the position of those children? Will they automatically become permanent residents because they have inherited the property? That is one aspect. Second aspect was that this particular law is applicable where you transfer the property, inter vivos we call it, between two living people. What happens when the people die? But automatically by virtue of law of inheritance, the property gets transferred. What happens to this status of nationality? So this is a very vexed question, and a lot of deeper thinking is required for this. This judgment seems to have reversed the whole thing. But about the judgment, I can tell you, at that point of time, the Bar Association filed a review petition against the judgment, which is still pending. It is true that the state government at its own level filed an SLP before Supreme Court. Then again, as I told you, these decisions are essentially political in character. That SLP was withdrawn. Then they tried to make a law in the assembly. Perhaps they failed to do that. So the situation is not that certain as you say it.
So this is a grey area, confusion remains.
I would accept that. It's a grey area.
Okay, I'll go to the questions.
Yes.
Yeah.
Sir, isn't the verdict of the Honorable High Court of Jammu and Kashmir in State of JK versus Dr. Sushila indirect encroachment on the notification of 1927, Article 370 and also on the Article 35A of the Constitution?
She doesn't lose her right of property. Now understand this. She loses her status as a permanent resident. Now if you are a girl today and you own, say, a house here in city of Srinagar, if you tomorrow marry somebody outside the state, you will continue to be the owner of that house. We are talking of status as a permanent resident. Now, Constitution provides what are the privileges available to a permanent resident. Like in case of employment, you need to be a permanent resident. For you want to contest elections, you need to be a permanent resident. You want to become a minister or a chief minister, you got to be a permanent resident. Now we are talking of a status. So far as your rights are concerned, they are protected which you acquired before you got married, and also the rights which you will inherit under your personal law. So therefore, please do not say that she loses her rights. She loses her status as a permanent resident. One.
Next question.
Sir, do state subjects who acquire citizenship of some other country lose their state subject status?
Yes, she loses. Because you have to be first a citizen of India, and then you become a permanent resident of the state. If you are basically not a citizen of India, then you cannot become the...
So the legal position is clear that you have to be first citizen of India and then permanent resident of this place. And these two will only qualify you to hold all the property that you want to
and status. You can go for training.
You abandon the status, you acquire what we call foreign citizenship. So
So you are voluntarily giving up the Indian citizenship. Therefore, legally you cease to be
under the state constitution. You have to
Next
be
question.
Do you think that the Permanent Resident Disqualification Bill 2004, which was defeated in State Assembly 2 to 3 times, needs to be reintroduced as a fresh if the state feels that the Jammu Kashmir High Court verdict in Dr. Sheila Sawhney's case tends to erode Article 370, which gave special status to the residents of Jammu and Kashmir?
This judgment was announced at Jammu. I was at that time Advocate General. I got the copy and sent it to the Law Department with my views that they should challenge it before Supreme Court. That was followed by successive government in 2003. But all of a sudden they withdrew it, thinking what was the advice to them they brought a legislation which was passed by the lower house in state legislature, but in upper house it got stuck up and it could not be passed. Thereafter, another election came, and my party was in coalition. They were not having an absolute majority. We still hold that the law should remain intact as it was at the time of Maharaja. Therefore, once we have a political opportunity in the legislature, that means 2/3 majority, we will go for its amendment.
It's time for us to head into a break. When we return, we will continue with the discussion on Article 370. Welcome back. You're watching Constitutionally Yours on Rajya Sabha TV. Continuing with the discussion on Article 370. The other side of it is that there are certain emergencies in which the state could find itself. It could be a financial emergency, it could be an internal disturbance emergency, and similar law and order problem. In a situation like this, it is absolutely clear that the center, which is India, the government at the center, cannot intervene and cannot bail out the people because it doesn't have the power, till the government of the day really seeks them out and gets them in. Now this leaves a lot on the plates of the state, because then the state political machinery has to identify problems, and there may be situations where they may not go ahead with it or may not call an emergency, but the people may need some sort of a relief. So what happens in a situation like this? Sir, 370, it clearly states that even in case of whatever be the situation, you just can't intervene. Financial emergency, internal disturbance.
Disturbance, of course, is not, because internal administration, or as we call it, the limited sovereignty in that context, that is exclusively the state subject. That's for the state to what we call. But we don't think there is any difficulty, because what the experience we have for last now 65 years, what has been happening, defense forces, paramilitary forces are at the command of the central government. Then so far as the internal component of it is concerned, our law and order machinery and others, if they are sometimes incapable of handling the situation, invariably the central assistance is what we call requisitioned, and that's always handy. There is no difficulty. We did find in September 2014 flood situation, devastating floods. At that time the central forces do rise, they come to the rescue of the state government. There is no difficulty. That I think lack of this provision, or in a way say because of the peculiar situation in which we are placed and the status of the state as we are, I don't think this is in any way putting us or the people of the state at any disadvantage.
The special status, is it at times, could it be used to prevent relief from coming to the people?
Certain things have been retained by the state ruler, and those have found places in our constitution. Section 92 of the Constitution of the Jammu and Kashmir is a complete answer to it. Whenever there comes any emergency, we deal it under Section 92 and seek central assistance or central approval. So if it is not directly applicable, the emergency provision as is contained in Indian Constitution, but our Constitution, which has also been recognized by the Indian Constitution by Article 7, that provides an emergency provision, and that has been used so far, and there has been no difficulty in it.
Superb, sir. What you're saying is it's a one-way street. So people who need help here will seek the help, but if the other side wants to cross over and come to you have a barrier.
This is ours, and we were dealing whether we require it or not. When we require it, we have a way to go to the
So there is a milking cow available whom you can milk anytime you want.
In a country we can't say cow.
Zaffar sir,
Yeah, if you talk today, there has been financial integration between the state and the center way back in 1954, as a result of which various taxes which are enacted by the parliament, various taxing statutes, they are applicable to us here. So that so far as the financial integration is concerned. But what comes to my mind is a different issue. Whether this is 370 obstacle or Government of India itself is an obstacle. The recent example is of floods. During September-October 2014 floods, there were a lot of what we call as Kashmir diaspora in European countries and in other countries they were there. And Kashmir really suffered, badly suffered during floods, in particular the place where you are sitting, the water was here about 10 feet in the High Court itself. We could not come to the High Court at all. They wanted to send some help to us. That help could not reach here because they had to get the clearances from Government of India. Now here my 370 had nothing to do with it. I did not prevent them from sending that help to me. This is our own people working in Europe, in other countries. They had collected some money, some blankets, and many other things what are needed during the course
Relief
of floods.
material.
Yes, but they could not come. Ministry of External Affairs had said that anything which goes to Jammu Kashmir requires prior clearance from the PMO's office. So that is on the practical side of it, telling you that what help has to come. Second thing is that as on today, it is a reality. We are here, and the defenses are there, the communications is with them, the foreign affairs is a reality, looking real position as it is. Now if the people of the state suffer, where will they go? They want to look in any other direction, you don't allow them to see in that direction. Themselves what they wish to do, they cannot do that because they don't have the resources. So they have to look in a certain direction. So therefore, whenever we are caught up in a certain situation and people have no choice, when people have no choice, so I don't think we can say that India is a milking cow and giving milk to us. It only holds true where people had a choice. Now I'll give you another instance. Sometime back it happened, unfortunate incidents took place in 2008 and 2010. The people said we want to trade. The Jammu-Srinagar trade was closed. A lot of people got killed, many trucks were burned. So the people then said that, look, you give us an alternative to the trade. Jammu and Kashmir is landlocked. It has so many countries around it. So they said, no, we need some route which will take it to the other part of Jammu and Kashmir. So there were some arrangements, some talks went on, and as on today, some routes have been opened through which the trade is taking place, subject to the Government of India's restrictions. So the question is, when you talk of this, we need to understand, do we have a choice? If you don't give me the choice, then of course the answer is simple. I have to go one way. Give me the
I've got
choice
the point.
and give me the choice and then see my decisions.
Right. The questions now.
On the one hand, we are defending Article 370, while as at the same time, in case if there arise financial emergency in the state of Jammu and Kashmir, we will be exposed to tremendous crisis. So what can be done in case there arises financial emergency in the state of Jammu and Kashmir?
We will have to look only at
Only
our
towards
friend.
Delhi, because we have a Provision 92 to look to the Delhi. We can't look to the Pakistan, China or Afghanistan. That is,
There are no choices, no?
Then will be enemy agents. Therefore, we have only one choice to look to the Delhi. That is why 92 of our constitution provides. That was our ruler has retained this power, not given to the central government, not given to the parliament. But in as Mr. Shah rightly said, for last 60 years we had no such problem that we could look towards any other area except the Delhi, and they had no problem to extend whatever they wanted to given by way of assistance.
There are many power projects which are presently under the control of Government of India, and the state is not getting its due share, where the land and resources belong to state of Jammu and Kashmir, and all this is happening despite of the state being guarded and protected by Article 370. Isn't it the exploitation of resources also, but it's also exploitation, it's also violation of Article 370. Sir, what's your take on it?
Natural Hydro Projects Corporation, which is a fully owned corporation by Government of India. Possibly one reason was that today power projects cost a lot of money. 1 megawatt of power project may cost you about 8 crores or 9 crores, just 1 megawatt. Now, in the initial years, when the government was a power thirsty state, they wanted to have power project, possibly, I don't know, possibly they may not have sufficient funds at that point of time. So they entered into some kind of agreement with the central government's NHPC. They set up these power projects, but what this NHPC did, it has turned out to be a white elephant. It provided only 12% of the power. Only day before yesterday, NHPC could make 20,000 crores out of the total power project which are with them. whereas the state's own Power Development Corporation could only make 8,000 crores. So there is a very strong, powerful movement now in Kashmir that a time has come when these power projects should be returned to the state of Jammu and Kashmir because they are founded on the state's resources. Now we have few more projects which are now directly financed by the state government, by the contingency fund of the state government. So they are setting up power projects of their own. So what perhaps she is saying is, yes, I would share that view with her if the power projects are returned, because then the revenue comes back to the state government. And that is what is much needed. As on today, that revenue is taken by NHPC.
Correct, correct. The
That's what
central
she's saying.
agency.
The central agency. That's what she's saying.
Next question.
Shall we consider Article 370 a constitutional myth or a democratic reality?
I don't know what she means by democratic reality.
Reality and
What
myth,
does democratic
constitutional
reality mean?
So because
Constitutional provision, it is there. Of course, it's embedded in constitution very much. And as we say, that though it suggested it is temporary in nature, it is not so. It is not so.
So it has acquired permanency according to you.
Yes.
According to us.
Right.
then why debates are going on this
No, it is not
particular point
outcome of
that
any
this is
democracy.
temporary
It is
provision?
not, if you are saying that whether Article 370 is the outcome of some election in a democratic process, no, it was incorporated in the Constituent Assembly in the situation in 1947. As I told you, few factors: the UN resolution, the incoherent and conditional accession with the central government dominion of India. These factors resulted in crafting of this particular provision.
I remember the words
370.
of, with due deference.
Yes, sir.
I remember the words of Sardar Patel, who was the Minister of States at that time,
Yes.
heading this states reorganization.
Yes.
He said that this is a device, Article 370 is a device to continue the existing relationship with the constitutional relationship with the state.
State of Jammu and Kashmir.
Sir, keeping in view the 6th Amendment, which was made in 1965 to the Constitution of Jammu and Kashmir State, which changed the nomenclature of Sadr Riyasat and Wazir Azam, has the state of Jammu and Kashmir gained politically as well as legally by this amendment? Was this amendment necessary, or was it simply an erosion of Article 370?
Sadr Riyasa, you have done away with Sadr
Sadr
Riyasa,
Riyasa
you changed your Prime Minister
and
to
Prime
Chief Minister.
Wazir Azam.
And her further question
Sixth
is,
Amendment of the-
when you were in power,
No,
why
no.
have you not reversed
No,
it?
no, why
No,
not?
her further question is, when you were in power for 20 years, why have you not reversed
Reversed
this
it, yes.
simple constitution amendment in our state constitution? Nothing to do with Indian constitution. They
Yes,
did
sir.
it.
Yes. You are right. This sixth amendment took place when my party was not in power.
yes.
It was done, and later on, when this committee was constituted for redrafting of this retaining the powers, it is incorporated there that we will do it and we will restore the position.
Indira Abdullah.
Therefore, we could have done it earlier, as Mr. Shah has just now hinted to you that you could do earlier. But we never wanted to take an issues which can create a bitterness between in the two region and between the J&K and rest of country. In a definite and cool atmosphere and in fair atmosphere, we want to its restoration, and we are committed to its restoration.
That's all we have time for in this episode. We'll be back with a new issue and a completely new High Court and a completely new discussion. Keep watching Rajya Sabha TV.